Good evening, everyone. Welcome to the Zoning Board hearing. This is a continuance of the ZBA 2403 for Kenneth J. and Carrie Ann Woods, 232 Old Main Street, map 107, lot 1, lot 15. This is a consideration of two variances, one for a setback and the other for allowing a detached ADU on the property. And we continued the last hearing because we had no hard evidence of the location of the septic system. And we have had an opportunity to review the files, and I want to make sure all my board members have done that. Yes? Okay. Yes. And before I launch into anything further, I want to identify our voting members on the board for tonight. Steve Root cannot be with us, so in his place, I would like to ask Conrad to be a voting member and Lauren to be the alternate. So the voting members for tonight's vote will be me, Frank Anzalone, Heidi Lordson, Peter, and Conrad. That's 5. That's all we need. Okay, now that we've resolved that issue, we can move forward. Has everyone seen the attachment that was provided for the location of the septic system?
Yes.
Okay. All right. Is there any further thing you want to add or any comments from the gallery that want to be made? Does anyone have any questions, further questions for anyone? All right. Are we ready to continue to move to discuss this? All those in favor, I will entertain a motion to that effect.
So moved.
Moved by Conrad, seconded by Conrad. All those in favor to discuss signify by saying aye.
Aye.
Aye. Opposed? None? Discuss. Okay. The point I wanted to make is that this diagram that we've been provided by DES, which is the only one on file, dates 1971, and shows the house before the addition of 3 bedrooms and 2.5 baths. And the unit, which correctly identifies my hunch of where the leach field was, and is being offered in evidence for that purpose, to indicate that they cannot do an attached ADU because the leach field is in the way. I do want to point out, though, that it appears that we now have a structure that has an undersized leach field, and I would hope that the planning board would continue the lot loading analysis as part of the ADU application when they receive it. I'd hate to be in a position where we allowed you to go ahead and realize that there isn't sufficient land area to correct it. God help us if it failed. That's my point. I guess I just need to take it all into consideration. But once again, the purpose of this for us tonight is evidence of location of the septic system, which we kind of had a hunch on in the beginning, but now we know that that's what it is, and it is presently located there. That together with the other ledge, which was testified to, the mention of ledge in the application for the leach field, it confirms our assessment of that and creates the hardship created by the land, evidence of the hardship of the lot itself. Do I need to go over any of the other criteria that we discussed last time, or you want to review them so we're all on the same page?
I'll review them, but I'd like to answer that the septic system, my experience has been that when you go before the planning board,
Turn it on, I guess.
It is on. Can you hear me now?
Yeah.
So when you go before the planning board, part of their requirements is that any changes to the number of bedrooms, you need to provide a septic system. They can keep the system they have until it fails. They need to have an approved plan in place. Also, when they come in for a zoning compliance permit, they need to prove that you have a septic system that you need to have the design in place in case the system fails.
Understood. I just want to make...
Correct. So as part of the conditional use permit process for the planning board members will look at the approved septic system for the ADU, and the licensed designer, in order to get that approval, will look at the lot loading and the septic on the site-wide to both support the main house and
Fine.
for the ADU.
Just want to make sure it's getting addressed. That's all.
So after our last meeting, I kind of went through the conditions. Would you like me to read what I have?
I was going to ask you for a motion to approve.
So I will make a motion to approve with the following conditions: that the applicant must apply to the planning board for a conditional use permit for an accessory dwelling, and that the height of the the height of the structure that falls within the 50-foot front yard setback may not be vertically expanded any higher than the existing ridge.
And I will ask all, that's good, thank you, Frank. I will ask you, all the other board members, if they would like to consider any further conditions to be placed on this, the granting of these two variances.
I just wanted to make a point where, and I don't think we've discussed this, but with the ordinance, there's the allowance of accessory dwelling unit, and within our definition, it has to be attached, right?
Correct.
So I think what's before us, and it's important that we have the discussion about why we're detouring from this, or if we detour it with conditions, that we actually do not permit detached, right? So that's not even allowable under the ordinance right now.
Correct, but
And-
yes, go ahead.
Yep, so then if the variance is going to attach to a conditional use, I really think, and I think it might need to be tied to a lot of the evidence that we heard about a disability and maybe the conditions that we're finding of the septic system and the impossibility of the lot. We just have to be very careful in how we craft any sort of allowance of this, because I think as the strict interpretation of the ordinance is it's not allowed. And that's what the town's saying.
Correct, but the
Yeah.
variance permits us to waive any provision of the ordinance.
I think that's the thing. So, yeah, I think that's where we're getting the variance, where
Right.
if it's not expressly permitted, we still have to hear the variance on it.
Right.
But then I think the next step is trying to really understand where we're allowing this, so that there's some sort of like standard of the deviation here, which I guess that's the concern.
So should we add a condition that the third condition being that the accessory dwelling is attached to the garage and is in the direction away from the street? So now we're kind of, again, this is where a plan would be great.
From the angle of wanting to establish the finding of fact for how the decision is made? I mean, is it not so much another condition, but us just stating the fact is that this lot is unique from the others because of the ledge that exists and because of the location of the existing septic, and those are the conditions that are special to this lot that allow you to grant this, so that it's not just a blanket.
Right, but
So-
Yes,
don't
I
we
think
need
it's
to
also the
include-
discussion, did we find that, and there also, I think it's a discussion that the applicant was lending to, where if we do not find those standards were met, because of the fact that it's not expressly permitted, that there is the statute that would allow it because it's someone with a known disability. And that's kind of the limitation that would allow you to overcome something that you couldn't otherwise. Which
So
I just
we
don't-
have that in our finding of fact. It's in the record as to the owner's intended use of the accessory dwelling unit detached.
And yes, it's not in the conditions we just talked, like, if Frank has that.
It's
like,
not
that
in the
would-
conditions,
yeah.
no, but it's in the testimony of the facts presented by the petitioner, the reason why they wanted this detached ADU for the purposes of caring for their daughter. And that was one of the things we considered in our deliberations. Now the question is, do we want to put that?
Well, I think that's the thing, if you're using it as, like, we're saying we're using that as evidence to find that this variance should be granted.
Yeah.
Then I think that then it should necessarily carry with the variance, right? Because if we're using that as evidence, it should be part of that variance that we're granting.
But
But then how do you enforce it once the property's sold?
So but the RSA to allow for a variance to be granted based on the occupancy of someone with a special disability, a known disability, is if you don't find the hardship.
Exactly.
Right, so I think first, just like Lauren is saying, the question of, do we find the hardship? Are those, the ledge and the septic, does that constitute the hardship? If the answer is yes, then we don't even consider the RSA. If the answer is no, then we move to the RSA. So the motion that Frank has made is in support of finding the special condition, is that correct?
yes.
Okay.
So then you wouldn't need the evidence of the disability, exactly.
Right.
Yes,
Yeah.
Okay.
thank you for clarifying.
Do we want to go through the 5 criteria again? I agree with Michael, all the meeting minutes that they'll put together will be the evidence that we need, because we've already talked about this.
Yes, I just think if a board member is making their decision using any of the evidence that the disability is getting you over that, or that is some strong consideration in this, then we need to
Yeah,
find that
that's-
there's no special condition exist. And
Then-
that we are deciding because of the disability and the evidence we heard.
Was that
That's
evidence-
overcoming the hardship. That's
Right.
typically the hardest thing to,
Was that evidence of the disability probative on the issue of hardship? And the answer, I think, was no, because we found enough other hardship with this lot. Am I in agreement with the board members on that?
No,
I mean,
I agree with you.
'cause if we,
Between.
you're right, if we bring that in,
well, I think it's a limiting factor, right? So I think that, but that's a large part of the presentation. So I think we have to be careful of that, because if, I think that's, I think it is being considered, or at least what I was hearing.
it's hard to put the toothpaste back in the tube. So, yeah.
Yes, but I felt that what distinguishes this property from other properties is the location of the house. It's limited with the front yard setback and the right side yard setback. The back of the house has ledge on it, and that you can't build on ledge. Ledge is not a solid, it moves, it cracks. If they go remove the ledge, they'll damage the foundation of the existing house because that happens to be on it. And the left side also has ledge, and the one corner they can build on is where the septic system is located. So they can attach the accessory dwelling, which is why I think that property is different than all the others in the neighborhood. I don't think we need to go on to the disability.
No, I don't think that we do either. It came up, but I mean, I
Oh,
don't,
it's, yeah, I think it was, yeah, it was.
Oh, it's the reason why they need an accessory dwelling. But
So would it be helpful if the motion, sort of a preamble, carefully says, on the basis of finding the 5 criteria have been met owing to the special conditions of the property, so that you're sort of setting this is why we're voting that it's met the 5 criteria, and it sort of divorces the 2 potential avenues, and the decision you will be making is based on the land, not on the occupant's disability.
right.
Does that help?
I guess I'm going to have to write this decision, which I'm happy to do.
I mean, I
Yes.
just wrote that down.
Exactly.
so-
No, I'm happy to do it.
Just interject.
Please do.
But the reason he's asking for an ADU is for a special needs individual. I think that's being overlooked. Otherwise, maybe he could go up, maybe he could, I don't know what the other options are, but this is a special needs, single level, easily accessible by a special needs individual.
Right. That's a good point, Ann.
yes, but anyone can apply for an accessory dwelling. It's not,
Predicated on having,
But not necessarily a detached. I think that's another kind of.
well, I'm sure you would prefer it be attached to the house, so much easier, right? But they don't have a choice, so.
And I think you, in some ways, have to forget the details of who the occupancy is and say, if this were just any other occupant that was coming to you wanting an accessory dwelling unit for any reason, would you find the conditions of the land meet the hardship criteria? If it's yes, then I think that's the decision. If it's no, then they have the avenue through the RSA that allows you to grant a variance that does not meet a hardship specifically to the occupants. And though I know, it's hard to just sort of forget the things that we know, I think that is, this video becomes part of the record, it would see this conversation is in there and it would happening, this becomes basis of, of the finding of fact. If that's helpful. I mean, because I think it really has to be taken in 2 different, completely separate processes. One, if not 2.
right.
Agreed.
And I think we've dealt with 1. I'm sorry, I neglected to mention that Julia was present. My
Could I
apologies.
ask a question?
Apologies. I was under the impression you weren't going to be here. That's why I was caught unprepared. Yes.
Chair. The case law, however, says increased expansion should be considered in cases with people with special needs, doesn't it? There's a case decision on that.
But that's,
Did you,
go ahead, Michael.
I'm not familiar. Do you have the site? Do you have the case?
No, that's if option 2.
If option 2 is brought into play, which it isn't, because we are finding sufficient hardship based on the physical characteristics of the lot, therefore we don't need to look at the disability as a reason for granting the variance. It's either the disabled individuals' considerations or the hardship of the lot caused by the physical characteristics of it. It's an either-or. If you don't find physical characteristics sufficient to find hardship, then we go to the other option, which is this is for the care of a disabled child, and therefore the statute allows special relief in that instance. Am I understanding that correctly? Yeah?
Is it helpful if I sort of give an example that maybe, so say someone needed an oversized garage so that their wheelchair van could fully extend the ramp in the garage, but that took them into the side yard setback. The reality is there's not a hardship for someone just needing a garage. It could fit. They need a special garage condition in order to meet their the needs for their special need. Otherwise, there's not a hardship there. They could fit a standard size garage, they could rearrange, and so the law allows for you to grant a variance when a hardship has not been met. In this case, the motion Frank has proposed, you're saying a hardship has been met, and so then the special needs section becomes irrelevant.
Right, right. All right, so
That means-
I have something else to add. Granted, I was not here last week, but I have watched the video. I cannot find anywhere any description of what this addition behind is going to be, how far off it is, what the square footage is. We heard 1,000 square feet. We heard 1 bedroom, 2 bedroom. Because I listened to it, we had a wife and a husband saying 2 different bedroom sizes. I'm a tad confused over actually what the structure is going to be like behind the current building.
Well, what we do know is that under the ordinance, it's limited to, is it 1,000 or 1,200?
1,000.
1,000 square feet. They have to put a kitchen in there. They have to put a bedroom in there. And for septic loading purposes, they're considered to be 2 bedrooms, aren't they? Even if there isn't 2 bedrooms because of the functions of the kitchen and the laundry, so they consider it?
Not necessarily.
Not necessarily, all right.
Yep, there's a base level for any housing unit that gets then added into how many bedrooms.
But is
Okay.
it clear that like a detached accessory unit that's not defined would then have to follow all of the restraints of an accessory dwelling? So that's an automatic there.
Yes, so,
And so-
Ann,
and
there's, they have to apply to the planning board, and there's conditions that have to be met.
And it's at that
Hopefully,
point,
somebody will get a drawing of the place so it's in their file.
Yeah.
they will have to
Septic
produce.
system's pretty weak.
Seems to me they would have to produce a drawing for the planning board to review.
Right, this does not
That's
get
their
them-
bailiwick, not
This
ours.
does not get them out of the conditional use process. It just means that the planning board can actually hear the conditional use process.
And that third condition I proposed, just strike that because the site plan they submitted shows the location of the accessory dwelling.
Okay, so we just have the applicant must apply to the planning board for a conditional use permit for an accessory dwelling unit, and the height of the structure that falls within the 50-foot front yard setback may not be vertically expanded any higher than the existing ridge. Is that?
Yes.
Okay, and I'll ask this one more ugly issue. I sat on this board when we had an application for a variance down by Little Sunapee, and when we reviewed the file, we found out that there had been a variance granted before that included the provisions, no further expansion. And what they wanted to do was close in the deck on the back. And because of that, we denied it. So the question now before you is, do you want to put on a third condition which says no future expansion, period?
You don't even know what it's going to be.
I understand that,
Right,
but we
they-
don't
they
want them
would-
building the thing and then
they'd be
coming
limit-
back to us 2 years later and saying, geez, can we put a deck on the back? I
Right.
mean, we need to,
Well, it's
I'm
also,
wa-
do you have to put the condition that it's attached to the garage?
yes. Yeah, that's,
Based on what they submitted, it should be attached to the
Yeah,
garage.
but I think that's when Ann's point is.
Yeah, we don't know, Ann, this is all we have.
Because we don't have we have a
This looks attached. Yeah.
yeah.
No,
And the
Michael, I-
dimensions seem to follow the same width as the garage. There's no bump
We
out.
don't have the width of the garage.
No,
We don't have the width of anything. I mean, if you guys don't want to cross your Ts and dot your Is, it's fine, but
Can I go back to the deck question, though? I had a question on that for the future. Is there a reason that they wouldn't be allowed to get a building permit for a deck?
No, Michael,
I'm just throwing it out, because I know we've done it before.
Right.
I'm just, we
But they would
have a
still
very,
be
we
limited by
we have a limited
the square
hardship.
footage under accessory dwelling and all the restrictions.
But not
You're saying
exterior,
no.
not exterior space. The
Yeah.
1,000 square feet is interior living space. So
Yeah, no,
somebody could
I
have
I mean,
a,
I'm just thinking, we've got a lot with granite quarries in the bottom of it, a side setback that's too small, we're sitting on ledge, we have a only limited place we can put the septic for the house.
I don't want
And
us
now-
to do something now that will limit them 30 years from now. A lot changes in 30 years. Yeah.
Just
I mean,
asking.
I see what you're saying, where it's like, if we are getting to the point where, this is a limited use based on the lot, and so what we're saying is this is the allowable use based on that plan, which I think Ann has some value in that, what we're saying, again, the plan that the owner's putting forward has to kind of go with them on what our approval is, because we're saying it's attached to the garage. But that has to kind of go with us to the planning board, because we're only saying it's allowed because it's attached to the garage. I think that went with a lot of
Well, I guess
that
what we.
discussion.
I guess what we could say in the opinion is that the drawing provided by the petitioner to the board for the board's consideration indicates that the accessory dwelling unit attached to the garage will be the same width as the garage.
Yeah, I think, well, that's.
And we only know can only be as high as the ridge of the garage, that's a condition of ours. And in order to get their 1,000 square feet, they're gonna have to figure that out, but based on the appearance of what we were presented, we're presuming that that's what it would look like. I don't think we can go beyond that.
No, I don't, the only neighbor that will see the property was here, and they had no issues with it. If they had an issue with it, then I would start to restrict the width and everything else. All the other, I'm just worried about the height.
Okay, what do you think, everybody, on that? So I take it that the no further expansion is not an acceptable condition to the board, so what are the two remaining ones that we have attached to the approval of this variance application?
the requirement to go to the planning board for the conditional use, and that the portion of the structure that falls within the 50-foot front yard setback may not be vertically expanded any higher than the existing ridge.
Okay, all right, we all comfortable with that? Does anybody want
I
to
think it
add?
has to be attached to the garage per that plan. I mean, are we saying that that's?
On
not
what
allowed?
basis, under the variance criteria? I'm,
Well, what do you mean by that?
well, what is the rationale for putting that additional condition on the variance approval based on what it is, the purpose that the board is trying to do with respect to the variance?
Because in trying to find the 5 factors, we all considered that it'd be attached to the garage. So without affecting the adjoining property's values, we discussed that it's attached to the garage, you won't see it. It doesn't affect the abutters because it's attached to the garage, you won't see it.
And
It's a big,
oops, I'm sorry, and it's easier for the intended occupants to get from the garage to the unit, the dwelling unit, because it's all one level.
yeah.
You make
I
a good
mean,
point.
Yeah, it was a
Because we're-
consideration throughout.
Is this enough evidence, or do we need to make it part of the condition? Because
Yeah, exactly. That's not to scale.
I guess to Ann's point, where I agree, where there has to be a certain level that's following our decision. So we have reflected on that quite a bit when we were finding the conditions met for this variance, which included a lot of discussion about it being to the garage and the side of the garage. The garage is also the non-conforming in the main street because that's,
Right.
doesn't have the setback, so
So
it
we were
has a lot to
permitted-
do with it.
We are permitted to add on to the back, but we can't, because that wouldn't make the setback from the street any worse. So they're only permitted to add on to the back of the existing garage. That was,
And the
that was
reason-
that argument.
Well, I think if you're going to overcome, I guess, your worry a bit about not having a plan, if it needs to be attached to the garage, then it arguably is attached to that plan a bit.
Well, I'll throw one more monkey wrench in. There was some discussion about parking. Because right now, it's up
right.
front, period. I don't know if that got resolved.
I think the conversation was, either it was a condition, or I didn't have an issue with the parking because they're going to park inside the garage.
Right. That was
If the
mine.
van fits.
And the parking criteria does fall under the conditional use permit requirements, so the planning board would have
Deal
the
with
ability
parking.
to waive.
I
Lauren,
guess to go back,
Can I just ask a clarifying question? Sorry for the notes. Attached or within the garage, would that be an okay way of phrasing it? Just thinking that when they get into the nitty-gritty of designing this, that, maybe an entryway mudroom or some portion is within what is now the existing garage, that there may be some of the existing footprint that falls outside of that 50 feet that is used in part with this new structure. Does that make sense? That it may not be.
Makes sense with the builder.
yeah, to go back to your original question, is the evidence in the minutes enough, or do we need to make a condition that it should be attached to the detached garage?
I think we should make a condition
I
that
think,
it's
that I
attached to
agree.
the garage.
I think we should add that number 3 then, that the accessory dwelling unit must be attached to the garage.
That then more closely follows your original ordinance, which says it should be attached to the dwelling. And so he couldn't do that, so he searched around, and he has this as an existing thing, so I'm trying to be close to what the rules say.
Rather than a freestanding ADU,
Yes.
it should be attached to the existing garage.
Yeah, when I looked at this, the impact on the neighborhood and the first 4 criteria, having it attached to the garage was very little impact to the neighborhood. If they were to build this from scratch, if there was no garage, I would have looked at it differently.
But what if it's 1 foot detached? Or 2 feet?
Right.
Or 3 feet? So then the condition becomes it makes it impossible, right? So I also looked at the minutes and the video and read all the files, and no, I don't vote, and no, I wasn't here. But I'm trying to understand if the board has already gone through all of the evidence and made findings, which I thought it did, the way we started the meeting today, that the variance criteria had been met.
Pretty much.
And there were 2 conditions identified. And now we're talking about placing additional conditions that actually could in fact become impossibilities for the applicants to actually make use of the variance we granted. Then what is the point of granting the variance?
I'm not
Right?
sure.
Because
No,
if you say it has to be attached to the garage in order for it to meet now it's a condition, right? The variance criteria were established, they were met. That's what the board found in the interim. If they go through the planning board process, they go through the design process, and they present plans, and they get designers, and they go through all of those other processes they have to go through that are outside the scope and the purview of this board, and they are told, oh, sorry, it can't be 3 feet, which is what the zoning board said, it has to be 4 feet, or it can't be attached, it has to be 3 feet, and we've said it has to be attached, then their variance is no good. To what end? Then they have to come back? If it's not actually a criteria, and it's not necessary for the spirit and the law of the variance to be met, then what is the purpose of the condition? That's what I'm struggling to understand.
I don't think there was ever a
No.
question before the board as to whether or not this ADU would be not attached to the back of the garage. I don't think there's anybody here sitting
Well, I
here. I
think
can't
that's
speak for
the
you
thing.
guys, but there wasn't any question in my mind about whether or not it would be built onto the back of the existing garage.
But does the lot not by its very nature present certain physical characteristics that have to be worked with by the applicants when they go to the planning board and work with designers and architects to figure out where you put the thing? So if it has to be 1 foot off of the garage, it no longer meets the zoning board variance.
That,
But I think that's by design, right? Because what's presented, it's not a plan that we're coming up with. owner's bringing us a plan that has it attached to the garage, and that's what I'm looking at.
We're doing it
to
in the
make
reverse
this-
order. They're asking for a variance from the requirement, and then they're going to go to the planning board, and they're going to have to present a plan, and they're going to have to go through an entire process, and if that doesn't work, then then they're back to the drawing board.
So
But maybe-
having it attached is a restriction. If they can't meet that restriction for some reason, I can't see why, then they'll have to come back here. When we looked at this, we all looked at this, that it was attached to the garage. And yes, the variance is for allowing a detached accessory dwelling. I know we're getting into, but my
Detached
question.
from the dwelling.
Yeah, my question is there enough evidence in the meeting minutes and so on to show that this needs to be attached to the back of the garage, or should we add a third condition? Because I don't want the planning board looking and going, oh, there's two conditions, and that's where it ends.
But I
I
think
don't have a problem adding a third condition that says that it needs to be attached.
It's kind of
to the garage.
intuitively understood that it would be attached to the back of the garage from the beginning of the discussions and the diagrams presented by the petitioner. Yeah. I don't have a problem attaching that condition, just to be sure.
But you are right. If we set a condition, and based on all the conversations we have, if for some reason you can't attach it to the garage, they're going to have to come back.
It has happened. It has happened
And I
before.
think that then you have an analysis for something that's different, than it's not before us.
Right, and so that's why I was trying to understand, because I did not detect from reading the minutes and watching and listening to actually reading the transcript, that the variance criteria had been satisfied because of the attachment to the garage. That was, so that's why I'm asking, I'm pressing this board to make a clear record so that everybody understands that you found the variance criteria satisfied because of evidence that the ADU would be attached to the garage.
And the owner's
If that's-
application had a plan that was attached to the
Right.
garage. So I think that's the evidence we were reviewing on that night, and that the conversation revolved around that.
And I think we should make that clear. Just because you have that question means someone else will have that question, which is why I proposed the third condition, that the the detached accessory dwelling needs to be attached to the existing garage based on the sketch that was submitted.
And that you're saying, the board is saying that you're finding that the variance criteria were satisfied because this unit would be attached to the garage. If it were not attached to the garage, then you would have had a different finding. That's what you're saying.
Personally, yes.
Yeah.
Okay, that, to me, that is clear, transparent, helpful to the people who are trying to move this forward so they can then complete the process, and if they hit a roadblock, then they know why they have to come back. And that's why I'm asking the question.
Can I ask
we all
a
clear?
question? Sorry, can I ask a question?
Thank you, Julia. I appreciate that contribution to this.
If, just using this picture up on the screen, so where the human door is here, if this were to be converted, instead of being open to the rest of the garage, to a mudroom access that then leads into the rest of the finished space, would you be okay with that? Would it be okay if the existing footprint of the garage also had maybe a small fraction of the ADU? Or you're saying all 1,000 square feet of the ADU should be newly constructed space on the rear? Does that make sense?
It does, and I don't want to get into that.
We're
My
going to get into
proposal
a
would
hair
be-
spliters convention
Well,
here.
but the planning board,
But I
will have
think
to
either
interpret that.
of your hypotheticals fall within that plan that we're seeing, which the two boxes are attached, and that's what we're making our decision on. So you're still not showing a deviation of those two boxes in that analysis, where it's
So would
like,
you be comfortable if the condition read, the detached ADU shall be attached to or within the footprint of the existing garage?
We have to be careful, because now
You
you're
have to
getting
be
into the
careful
parking.
because any construction that goes on in there for the ADU is in violation of the front setback.
Right, but the planning board
that's
would
what-
know the portion of the front of the garage is within the setback, and they can't grant for that space to be finished or converted from the garage. That doesn't mean that the back 15 feet of the building that's outside of the 50-foot setback couldn't house finished interior space.
Oh, it can.
At-
Yeah, I see.
Adam, can you read that back?
The detached accessory dwelling unit shall be attached to or located within the footprint of the existing garage.
I don't have a problem with that, and I'd like to make that my third condition.
Does that leave open the possibility of losing parking spaces in the garage?
Well, yeah, we need to make sure that, yes, that's true. I like that condition. But we should also insert the provision that the garage still contains parking space for 2 vehicles. We don't want them taking more a footprint away from the garage and adding it to the ADU.
So, Michael, I would agree with you, but if they can prove they can put parking somewhere else, then they meet the conditions.
Then they meet
So-
it, yeah.
Or if they successfully argue a waiver to the planning board, which is a power they have.
Well, we put it in our opinion that it was intuitively understood that they intended to retain 2 parking spaces in the garage. That was what we considered.
Again, too, I'd like to keep that in our notes, but I don't want to add it to a condition, because if they can meet the parking requirements, and for some reason they need to take up one of those parking spaces, cost, there's so many, construction, who knows?
Yeah.
If they can meet the conditions, then why add that?
Why add that? We still,
In fact, it would be better if the accessory dwelling some of it were in the garage, because what they would construct would be smaller.
that's true. There was testimony, though, from the petitioner that they intended to use that side door as entrance and egress from the ADU through the garage. I do remember that. You may. Push the button so it's green,
Yeah.
please.
So I believe what was stated is that we would add a side door. Because, right, accessory dwelling unit, the requirements for the accessory dwelling units are that the door access cannot be on the road side.
Understood.
It needs to be on the side.
So you didn't say you wouldn't going to use that door, but you would have a side door. I get it.
Yeah.
Understood.
Okay.
Yeah, thank you.
I don't want to restrict something that they would be allowed to do. So they can add parking spots anywhere on that property.
Understood.
I would
That's not
also
our-
add.
That's not our deal. That's the planning board's deal.
I would also add too, there's going to need to be a zoning amendment this season to address this because of or I believe so anyways, the webinar was yesterday, but state law is changing how many spaces we can require per dwelling unit. And so though that is typically handled through site plan review regulations, which is amended via just a public hearing of the planning board, this is the one spot where it's baked into the zoning ordinance that has it tied to bedrooms, which in this case would put us out of compliance. So there's likely one little thing that's going to change here that says we can't require more than 1.5 spaces per unit that meets an affordable space. So just saying there that
Okay.
don't get fixated on the 2 because this could be irrelevant.
So is it going up or down?
Down.
Thank you. Number of parking spaces required is going down, and yet the number of motor vehicles is going up. Okay, so figure that one out.
But the number of houses.
The number of houses is always a problem. Okay, I'm going to ask you once more, if you would be so kind as to read the 3 conditions that we have before us, and then we can perhaps we can take a vote.
Okay. So number 1, the applicant must apply to the planning board for a conditional use permit for an accessory dwelling unit. Number 2, the height of the structure that falls within the 50-foot front yard setback may not be vertically expanded any higher than the existing ridge. Number 3, the detached ADU shall be attached to or located within the footprint of the existing garage.
Located partially within. Partially within.
Noted.
Darn lawyers. Anyone have any corrections they would like to make to those conditions? Okay, are we ready for a vote?
Yes.
All those in favor of approving the variance with the conditions that we just read signify by saying aye. Aye. All those opposed? Hearing none, Congratulations, your variance has been granted with conditions. Now it is off to the planning board for you. And I wish you the best of luck. You're welcome. Do we have, where's my agenda? Do I have any minutes? I don't, oh, review of minutes, Well.
We have the 2 July minutes, or June and July. The 19th ones I realized today didn't get put on the website, but the 2nd of July and the 4th of June, you can take action on.
Yes? I'm waiting for you.
I thought we approved one last week.
We couldn't
did.
because there was only 3 people
Oh.
at that meeting, and we didn't have a quorum of who was there. So Julia, Heidi, Michael, and Anne can vote on the meeting minutes of the 7th when we met under the portico.
Oh, I get to vote? I get to vote? Oh,
You
exciting.
can make a motion if you'd like.
No, don't start with me. Okay, I would entertain a motion to accept the minutes, the earlier minutes from the date of July 2nd. All those voting members in favor of approval of those minutes signify by saying aye.
Aye.
All those opposed? Hearing none, the ayes have it, the minutes are accepted. And now we are dealing with the minutes of
June 4th.
June 4th.
Who is it June 4th?
Yeah.
Enough of you that we're not going to get picky about that.
Either way, no one's appealed it, so we're good.
We're not taking individual roll call votes, so I think it's fine for you to. Let's see. Michael, Ann, Heidi, Lauren, Steve, Conrad, Peter, Julia, Frank.
Hey,
Lauren, make the
she
motion.
gets to vote again. All those in favor of approving the minutes from June 2nd, signify, 4th, signify by saying aye. Aye.
Aye. Aye.
Thank you. Approved. All those opposed? Hearing none, the minutes are adopted. That concludes the business of this meeting. I will entertain a motion.
Can we talk about something?
On the record or off the record?
On record.
On the record. There's no other way.
Always on.
We keep getting these applications where they're so vague. A simple site plan, a simple set of plans, anything. What's that one by the country club where the woman gave us I'm not saying everything needs to be surveyed, but we need to understand what we're voting on.
What's the size of the garage?
It could be,
You could go on the property tax records and check it.
no, those are.
Not very accurate.
Those are bad.
Well, I'll go down there with the tape.
Applicants
Oops,
are-
I'm not supposed to do that
supposed
because
to-
I'm not a qualified engineer. I can't go down there with a builder's tape and measure the damn thing.
Frank's point is, where historically, I haven't been on the board forever, but when I first came on, I noticed that a lot of the conditions that we had, and we would send people back to go have the property surveyed, and many times they would come in with a substantial building plan for us to look at. And that seemed to be commonplace, and it's now not so much. But that seemed to be a practice that I noticed the board had as
I think you were hoping that the septic system plan would show a little bit more detail
No.
than it did, with besides squiggly lines and boxes.
Well,
Adam, can you overlay the Google map or any map?
the garage is missing from.
The garage is missing. So what good are those? We need to have something.
I also think for your concern, it kind of shows a bit of that, they've invested in that plan that they're bringing to us, and that it's more concrete, whereas it's not just, I think, kind of movable because
Yeah.
it's just thrown together.
Now you can see the garage and all the junk parked around the edge of it.
Come on, Michael,
Michael?
Oh, unidentified objects, sorry.
on video.
This is all taped.
Understood. They're
So, Frank-
unidentified objects.
So Frank, is there, you stated a view. Do you have a
Requirement?
suggestion?
It's hard because I don't want every applicant to have to go, it's like you start drawing this line and I don't want every applicant to have to go get a brand-new survey. If they can pull out a survey from 1984 that shows us that garage, we know how far it is from the property line. That's a start. And then when they say we're adding a dwelling or to the structure, well, what are you adding? Is it 35 feet tall? Is it 20 feet wide? Is it 5 feet wide? We need something. If this has an impact on the neighborhood, if they were to put that accessory dwelling and it's 2 stories and it's 1 story, 35 feet tall, I would have said,
That
this-
would have an adverse impact on
Thank you.
the property values of the neighbors. But how can we make that judgment if we don't know anything about what it looks like? Because the looks of it may have an effect on the property values.
But you can't, I would be very careful in making a conclusion about impact on property values
I understand that, but in the
based on a aesthetic characteristic, right? So because we're on the record, I think simply because something doesn't look a particular way does not and it looks different than, does not necessarily equal adverse impact on the neighborhood or on property values. To me, that is conclusory, and that is dangerous. So I don't think that's the conclusion we're trying to draw. I think that the point, Frank, you're trying to make is there needs to be a reasonable degree of specificity for the information that is presented by applicants asking for leave from this board for relief from variances. And if that is what we're asking, then perhaps we need to have a conversation about how is it that you relay to an applicant what constitutes some reasonable degree of specificity to allow the board to be able to make some sort of findings, because otherwise you will continue hearings, people will have to come back and back and back, right?
That belongs in the application instructions.
So that might be food for thought for what is it that people are being asked to do when they apply so that they can make their proof, right?
Yep.
So that's what this is about, I think.
Yeah, I
So-
agree with everything that you
Okay.
said. Where it gets complex is, it's up to them to make the application and to show us the proof. It's not up to us to kind of spoon feed this and constantly making conditions that could have been easily taken care of with a sketch.
Right.
Adam, when somebody comes to you, what kind of a conversation do you have with an applicant?
Typically it's,
Do you have an opportunity to,
right, and typically it's related to the type of variance they're asking for, so.
not so much the requirement, well, you do talk about requirements though, don't you?
Right, so the next thing I was going to tell you is that you have another meeting coming up in 2 weeks. We got an application this week. So let's use that one as an example. That is a variance for a garage in a front yard setback. So the conversation there immediately starts at requiring a survey, because you are granting a setback variance that you have to grant in a specific number. In this context, I think it's less clear, because it's not necessarily something that is specific to the other surveyed attributes that may lead you to understand that there is a hardship created with this. The detachment is sort of this nebulous, it's not necessarily anywhere in particular, it's just not able to be here because of the conditions of the land. Now, if those conditions were something that was only quantifiable via a survey, I think that is a reasonable thing to ask them. In this scenario, I know everyone drove by and you saw the ledge popping out of the ground, and there's other ways of confirming that. How I have handled it, and if it's something that needs to change, certainly, there's directive, but is specifically based on the case and the type of variance. So Steve Wright, for example, I think that was a year or so ago, when he wanted to go into the stream buffer he's on Checkerberry Lane, I believe, if everyone remembers, to allow for the wheelchair maneuvering around the bed. Had to have a survey. We're granting how many square feet? I think it was 4.5 square feet within that buffer. The gentleman out on 103A with the stream buffer encroachment with the greenhouse with the fruit had to have a survey. I mean, so I think there are scenarios where it's a given from the start. I know that the old Main Street barn, we advised them to have a survey. They wanted to apply without it, and then you guys requested that from them. And I think an applicant has that right, and they can give it a shot without spending the money, but they understand, and we try to be clear with them that may become a request.
We tried to impose a survey requirement for shorefront variances. And
That's absolute.
that didn't go over well at all.
No, that's absolute. That's
I remember
absolute.
Pete Bianchi, the selectman at
Too
the time,
bad.
saying these people can't afford it, and we're not going to reimpose a survey requirement on these people. It's too expensive. Well,
We can't go through that again.
And I guess, again, I would say it's dependent on what the variance is for. If it's this same
I get it.
detached scenario, just they have waterfront, that may, not require a variance. Maybe it does, I don't know, but,
So I think we're getting hung up on a survey. I don't want surveyors to be overburdened with the minutia, but not to put the dimensions of the garage that he wants to attach the ADU to, I think was a minimal request that he could have fulfilled. So if I had been here, trust me, I would have asked him to go home and do that. That's all.
you just have to be here next time.
Yeah, well-
and I do think
that's
we
it.
should
Sorry.
be careful not to talk too specifically about this application that we just closed a hearing on and are now having sort of a public hearing, but
I'd welcome
noted
him
in the
back to hear what he
context.
got away with.
Well, I don't think that's a question of anything like that. There is a lot of detail in between a drawing and a survey, right? So there are maybe some.
There's aspects of the building permits that probably could be added, where we're just asking for dimensions, very basic sketch ideas.
That would be in the application instructions, that would be enumerated.
Right, and it would be something that's specific to a structure, right?
do
Because
we-
for a use, you're not going to have,
And if we're going to ask you to
Right.
change those, we have to vote on that, yeah?
potentially, let me look at how.
As a board, don't we have to vote on the instructions? Or somehow otherwise approve them? There would be a major disconnect.
I don't think instructions, I think changes of procedures as far as the application goes, but I don't think
Well, whatever,
I
my
don't think
point
a
is,
supplemental, checklist necessarily requires your vote. I mean, we can certainly show it to you, but.
maybe we should review that. When we're giving the applicant the application for the variance, we should at least give him some idea what we
Or a
might be
special
looking for,
exception,
depending on
or
what it
whatever.
is.
Yeah, this is what I was afraid of. I think going forward, we just have to, what's been happening is we've been basically helping these people make their case.
Oh,
All right.
That's our job.
I know, it is our job, and our job is to evaluate what they present. I do this, I go before the zoning board, so when I see this, I'm like, that was a very approvable case. It should have been. But he was just missing that, sorry, not this case. There are some cases where they're approvable, and they just need that little help. Not everyone can afford a surveyor, an attorney, and make this presentation. So I think some of these cases, I'm gonna have to say, I need more information.
If that's what you're going to do, I, for one, would support that. Generally speaking.
One
All right.
comment, if I might.
So just,
And
sorry.
Addressing the rest of the board. I do not have a legal background, so I can look at the law and say, this is a known, all right? This is the zoning ordinance, and that's known. But it would help me a lot more be able, bad English. I would be aided by having a definition of what the variance is that I'm applying. All variances are not the same. They're not generic.
And that is what's on the application. That should be, that's their obligation with this, to go through and to spell out each one of the criteria.
Right, but beyond, the physical things, like big size of the garage is important, especially when we're looking at physical limitations in that last case. Uniqueness of the property. So describe it more fully so that I can appreciate the uniqueness.
Yeah, if they're giving a variance for like an ADU, a detached ADU, it would be helpful to know the dimensions of it. We know
Yeah,
it's limited to 1,000 square feet, great, but that can be a lot of different shapes and sizes. So we should, yeah.
I think it would be very, and the reason why I didn't want to kind of start this is all these lots, all these applications, they're very unique. For us to kind of set a standard that applies to all of them would be very difficult. It's up to the applicant to prove to us that they've met the 5 criteria.
I would appreciate if whatever they handed us had structures on it, the drawing, whatever, there were dimensions on it, that's all.
I don't disagree with that. Are we done on the record?
Yes, I'll make a motion to,
Please do.
and
I want to clarify that you're just looking for a motion to adjourn, not to have discussions off the record.
We are making a motion to adjourn because we have no more
Before you do that, I
deliberations before us.
just want to remind everybody that your next meeting will be October 15th, okay? Thank you.
I will
think
make a
I'll make a
motion to
note.
adjourn.
So moved. Do I have a second?
Second.
All those in favor signify by saying aye.
Aye.
All those opposed? We are adjourned